exceptional circumstances, my lord, for immediate lordship judicial interference in the matter of the Calcutta GPO, casual labor, my lord, just have a look at the order first 3 or 4 lines, my lord. This was the order. They are working in the directly under the department more than 20 years, my lord. Now they are asking from today to work under the contractor, my lord, because they have moved the writ petition before this honorable court, my lord. So either today, if it is possible, my lord, record it already has come from the court number 11, my lord, and or my lord, tomorrow let the matter.
Writ petition is pending. You have moved the. You have come after the CAT's order.
No, my lord. This is the order, my lord. Directly there was a observation of the learned one division bench of the High Court, learned CAT, my lord, that it is in their opinion of their lordship, it is the unfair practice is going on in spite of directly was the direction.
Have come against order of CAT.
That is the CAT order.
Oh. So what is the matter? What is so urgent all of a sudden?
My lord,
this is order of 21. You are
now, my lord, the fact
you have come in the writ petition.
My lord,
you have challenged the CAT's order.
My lord,
it will be taken up.
My lord, today, if it is possible to.
No, sorry, cannot be done today and tomorrow. This bench is only till tomorrow. Tomorrow also we don't know how long we'll sit.
My lord, but they are asking to work.
Don't know.
Work under the contractor from today, my lord.
Your case has been heard by the tribunal once. Yes. So, anyone else? Yes.
My lord, some urgent matters.
Not possible today, tomorrow.
These were pending before honorable court number 11. And
all right, give it that. If they were already on the list, they will come on the list. Yes.
My lord,
if they were on the list, they should come on the list.
My lord, at least the matter may be fixed, my lord, on the Monday, my lord.
We are telling you the bench is not available. If you can't understand, then we can't help you.
My lord, otherwise, because they are before the High Court, they are being punished, my lord.
Yes.
WPCT 184 of 2013. Out of list, maybe listed. WPCT 184.
No, we are not accepting your slip. There is no, we are not fixing it in any urgent matter. You try in the next week, yes.
WPCT 184 of 2015 is out of list. Can it be listed, my lord?
Why?
It is not listed for a long time, my lord.
We don't know. See why it is not listed.
Permitted to mention on WPCT matter for inclusion.
All inclusion next monthly list you give. All inclusions. Give the inclusions. Give your inclusion next monthly list.
My lord, sleep, lord.
Any inclusion? Any inclusion? Yes, give. Yes, now.
The first Justice Bhattacharya's leave, my lord. May I file the written notes of argument which my lord has asked me sitting in the division bench with Justice Bibhash Ranjan De. That appeal, my lord, which my lord has heard. My lord, and it was placed as to be mentioned to file a written notes of argument.
All right, you give it. But how it can be taken note of? It will have to be listed.
My lord,
we can
my
take
lord,
note.
the direction was by the order to be filed by 24th, but my lord was in search.
All right, then give it.
Lordship, may I permit it to mentioning this?
Get it, put it in the tag it with the connected file. Yes.
Lordship, may I permit?
Yes, same.
Lordship, may I permit it to mentioning this matter for this non-prosecution?
Give tomorrow. You have got written instructions. Yes.
My lord.
Yes.
I am the prisoner of this honorable court.
Yes.
I filed 2 charges, my lord, mentioning this matter on 5th December, 10th December. But this matter did not reach.
Which matter?
The synopsis of this matter.
What is the
is
case?
720 lakh rupees and
what is the case
of senior grade commandant. For this regard, my lord, again I request that this matter must be listed.
It is a CAT matter.
And fix the matter for final hearing.
Yes, then what is it? Why have you
It is
taken the slip without mentioning?
1806.
And you are giving the slip without mentioning. What is this?
Pilot asked to give the mentioning.
We did not, sir. We did not. We are hearing the mentioning. Yes.
Your Lordship, may I have Your Lordship's kind leave to mention this matter? Your Lordship, we are filing a writ petition challenging the order passed by Armed Force Tribunal. Your Lordship, the department has raised an defect as the order which have annexed here is a free copy, Your Lordship.
No, no, you get the certified. What is the urgency? Get the certified copy. If you are challenging, get it, file it. Yes.
Obliged, Your Lordship.
Yes. Yes. What is your matter? Can we see? Can we see what is your matter? Let us see. Give.
My lord, already I mentioned the matter.
You may have mentioned, you can't expect us to remember something from December 5. Let us see what it is.
5th December and 10th December already mentioned this matter. This matter already assigned by Honorable Chief Justice and Honorable Justice Patnaik.
Right.
So, sir, this is very essential. I am old person and now 82 years old. So, my lord, fix the matter for final hearing.
Has it been assigned?
Yes. Chief Justice already assigned on this matter on 3rd December, and this file kept on this Honorable Court on 3rd December 2024.
But you have mentioned
So,
in
my
your...
lord, may kindly fix the matter for final hearing. I am old person and now 82 years old.
You have mentioned in your slip
Yes.
that it was listed before the Chief Justice on 5/12/24. And you are saying on 3/12 it has been sent to this court. Therefore, we are asking you. You are giving a date of 5th December. The same will appear before the Chief Justice on 5/12/24. So what happened on 5/12/24?
Honorable Chief Justice sent this matter group 6 for this regard 3rd December this matter.
It can't be 3rd December. Your slip says 5th December.
Oh, 3rd December already issued the Learned Council on behalf of Union of India. So, my lord, this file already
File has come.
sent by Honorable Court
Is this file here?
on 3rd December. So, my lord, fix the matter for final hearing. I am the old person.
10, 12, here it is. It's a signed matter. Signed, only when we come back we can pick it up. See, this bench will not be available after tomorrow. So after 20th January, the bench will be available again. You mentioned then after 20th.
Yes.
All right. Yes.
May I take your lordship's leave to mention a matter? It's an old matter. Lordship was hearing it for quite some time. By dint of the 23rd September, your lordship had directed to keep the matter listed post the puja holidays. But post the holidays, it was never listed. And on several occasions, lordship, the appellants have not appeared. And it is recorded in the orders. And they're deliberately trying to keep it pending.
So
Kindly.
you have filed any application? There is an interim order or something?
No. There is no interim.
Then it will come. You are the respondent. Let us see. Unless the appellants want, why should
The matter be listed and the matter be
let
heard.
the appellants come? Then only we'll consider. Yes.
It's an assigned matter, lordship.
Yes.
The same matter, lordship.
So you are the respondent. Then what is the urgency?
Lordship was hearing the matter on several.
We have understood. You need not repeat the same thing. We are saying that if there is no interim order, if the appellant doesn't want to do it, then
Trying to keep it pending.
let it be
lordship.
pending. How are you affected by pendency? Yes.
Item number 1. But in this matter, my lord, I am for the petitioner.
The 2009 matter.
But I mentioned the matter before your lordships for urgency, my lord. But kindly look to my lord, the order dated 16th June 2023. There is a direction upon the Chief Secretary of the State, my lord, to decide the issue in terms of one of the notifications.
What is the issue? Please give us the background.
Issues, my lord. What has happened, my lord? Petitioner challenging the equal pay scale which is, my lord, given by the respondent authority to the LDA, lower divisional assistant and
Assistant.
lower divisional clerk.
And
We are
you
the
are,
lower divisional assistant.
you are also lower divisional
Yes, my
assistant.
lord.
Then where is the question? Then both will
And
have the
LDC and UDC, what has happened, my lord? Our, my lord, zone of promotion, feeder post is different. Our job responsibilities are different. What has happened? Now, my lord, a
we are not
notification,
able to understand. You are a you are a LDA or you are UDA?
LDA.
You are LDA seeking parity with LDA.
No, I am challenging the parity. That is fixed by the respondent authority, my lord.
Oh, you want a different scale.
Different scale. Because our job responsibilities are different. Now, my lord, there is an interim order, my lord, upon the chief secretary to hear out the issue and decide the issue within 3 months. Now, on December, in the month of December, my lord, hearing took place. But till date, my lord, decision has not been given. Kindly look to, my lord, the order dated 16 June. Sir, 12 তারিখে hearing টা হয়েছে।
The pursuant of mandate directions, but hearing has taken place on 12th of December 2024 at 4 p.m. And a resolution will be forwarded to the MIC before the government. Now, as soon as the government decide, everything will be solved.
So hearing has taken place.
It's already taken, and they have
On 12 December.
You
I
are saying,
mentioned the matter, thereafter they fix the date of hearing.
so now they will take the decision. Why do you want it to be listed?
Well, kindly see, my lord, kindly
Unless they
see, my
take
lord.
a decision, what is to be done?
No, my lord. That's why, my lord, because, my lord, the order is June 2023. And there is a stipulation date, my lord, within 3 months. That has already been elapsed. That's why I mentioned
3 weeks,
3 weeks.
not months.
3 weeks. 3 weeks.
Maybe, but the
Now, my lord, the hearing,
on 24/7 it was taken up by the same bench after 3 weeks. Bench has already extended, in effect, extended the time granted earlier. So
that has already been elapsed.
so that
the
3
period.
weeks now does not mean anything. Then it was directed to be listed on 9th August.
This is all.
And thereafter within a time frame as stipulated by the chief secretary. So what was the time frame stipulated by the chief secretary?
Nothing has been given.
Please see your order, the last
yes.
order of 11/8.
Has been formed.
Just a minute. 11/8/23 order. See the 11/8/23 order.
ঠিক আছে, আচ্ছা।
Tenure of the committee till 31st of January 2025. Has been extended by notification.
31st January.
No, the time frame is you have mentioned way before the time frame. Long before the time.
We did not have the knowledge about the time frame. Nothing has been provided to us.
Oh, it is of 23, 11/8/23. Sorry, I thought it was 11/8/24. 6 months. 11/8/23, the chief secretary said 6 months. Then what happened?
12th of December, last meeting has been held. Both the parties appeared before the committee.
We attended the hearing.
They made their submission. Now, written arguments, written submissions were filed. The committee has taken a decision forwarded to the government. This is the last information I got from the department. Kindly see the last notification issued by the government. And life of the committee has been extended till 31st of December 25. That is not also there. New pay scale has been introduced in 2019 report.
No, but this is too much now.
No, but the meeting has already been, decision has been taken, but it has been sent to the government, just.
The
for-
committee has sent its recommendation.
We have been sending, certain recommendation has been made and forward to the government for approval. As soon as the
So we are asking you, the committee has already sent its recommendation.
recommendation to the government
When?
on 12th of December 2024. Well, can you see that notice?
So it has to be placed before?
Before the MIC, Minister in charge of the finance.
The minister will take a decision.
No, but that also another normal rules of business. But if decision is taken, then MIC signature is approval is necessary.
That is,
A procedural.
that is a different
Formalities.
thing. Now you are talking about 163, 164 of the constitution. That is a different thing.
Yeah.
The decision has to be taken by which authority? That we are asking you.
The
Second,
committee has recommended grant to the government for just approval.
approval. So
Approval.
why it is taking so long?
No,
Nearly 1 month has gone by from 12 December.
in the meantime, some of the political executives were not in the station. But that's a difficulty.
Oh, but you please, because this matter has been pending since 2009. So, which department is this? What is the department name?
Par and finance, home par and finance,
Home?
home par. Home par, sorry, home
Oh,
personal.
personnel.
Home
Okay.
personal.
Home
and
personnel.
Only par.
Personnel.
Moved by the part department.
Then why should be, issue must be closed now?
Now, just we are waiting for the, it will file again, return to the government, whatever, executive. Then they will be notified, enough notifications or information to the of the public. What are the decisions they have accepted?
No, then you are waiting, then how long should we wait?
No, no, no.
You are waiting, that we have heard, but how long should we wait?
No, no.
You cannot expect us to wait endlessly.
2 weeks time, right?
Yes, give us a reasonable time. We are giving you 3 weeks. But we are saying that you should file a report after 3 weeks. Yes, Mr. Mukherjee.
for 2024.
What is the writing which was submitted? What is the date of the writing which was submitted? You please read from the bottom of the first page of 11/8/23 order. This can't have such a casual approach. Then what is this? This is a casual approach.
What about the decision?
Please read, sir.
Yeah.
The additional government period makes it over a writing by which the chief secretary directed. What is the date of that writing? He has said 6 months. So from that, what is the 6 months? Even from 11/8, 6 months lapsed in April.
Within 6 months, nothing could be done. I'm very frankly speaking. Then when the
But
last,
after 6 months, another 8 months is now passing. After 6 months.
Yeah.
And you are still asking the court to wait.
no, what are just we are waiting for the decision of 12 December.
That is what we are saying. You are still asking us to wait. And your committee has done nothing. And what chief secretary has done?
He has heard both parties. Finance to the sent to the finance department. As soon as finance
We are
department-
not concerned where it is. The chief secretary directed the committee to submit a recommendation within 6 months.
Yes, ma'am.
Why it has not been done? And why chief secretary has not done anything if it has not been done? This is not the way to deal with a matter pending in court.
No, certainly, Maharaj.
Then what is this?
But as soon
Height
as
of casual approach.
there is no casual.
There appears to be no seriousness on the part either of the committee or of the Supreme
Or
of the
some
secretary.
delay on our part, kindly excuse us. Maharaj, as soon as it is written, approved by the finance department.
We don't think so. Your past conduct does not inspire any confidence whatsoever. When your chief secretary's order means nothing to the committee, then why the chief secretary has not taken steps against the committee if they are not following the directions?
Maharaj, kindly see, there are 12 members of the committee.
However many members that may be, that hardly matters to the court. There may be 50 members.
11 September 2000. On 15 September.
You come back with a proper time frame tomorrow. We will record that undertaking in the order. You come back with a fixed time frame tomorrow. This can't go on like this. You ask the chief secretary to inform the court. Let the matter be adjourned.
Monday and Tuesday, I have some personal difficulty. Can it be taken for Wednesday?
You are in difficulty.
No, Maharaj, on Sunday, I shall have to leave Calcutta for native village. Sad ceremony of my mother.
আমাকে এইটা দাও আপনি সাথে যোগাযোগ করতে হবে
Next week, this bench will not be available.
But tomorrow, let them, my lord.
May I suggest, subject to your lordship's kind appreciation, let him file a report. Lord.
No. That report business now has to stop. Steps have to be taken. What is this report?
Because we do
Since the last 3 years, report is being
I
filed.
appear for the added respondents, but we do not know whether the meeting has been concluded at all. Because
So therefore, we are asking them to give a realistic time frame. This can't be, this is unacceptable to the court. We'll have to take steps if it can't be done by them.
Let them
Can't
inform
be like
tomorrow,
this.
my lord, regarding these steps, my lord, what's the status.
He's in difficulty, he's saying personal difficulty. Then
Coming week, then, my lord,
Hmm?
the bench will not be available then.
after 20th,
only after 20th will
20th.
be available. So inform us on 27th, on 27th, 27 January. Please, you inform whoever has to be informed. We are not going to take it casually.
No, certainly.
No further.
Serious matter.
This is enough is enough.
Yes, Your
Yes.
Lordship perfectly correct.
I appear to be added this point.
Yes, give your appearances, please.
Obliged.
I will-
Grateful.
Item number 2. My lord, I bring for this state respondents.
My lord, I am for the applicant in item number 2, my lord. My lord,
In, may I frankly respectfully, my lord, that this particular application was under challenged in 2018 before the Honorable Supreme Court. And my lord, in view of the order passed by the Supreme Court, my lord, this review application has become infructuous, my lord. Your lordship kindly comes to page 19 of the application. Page
19, my
of the
lord.
CAN application. My lord, from the judgment and order dated 25/6/2008 in 755 of 2024 of High Court of Calcutta. Being under the CAN, my lord. Your lordship has got it?
From the judgment order 25/6/2008.
My lord, 755.
Yes.
Now your lordship kindly comes to page 35 of the data of the state, page 35. In the High Court at Calcutta, my lord, being the order under challenge. WPST number 755 of 2024.
Page 35.
My lord, page 35 of the
Stay application, stay. Memo of appeal
My lord, the application for
for
review.
review.
Page 35. I'm just trying to cut short the matter, my lord. Page 35 of the review. The top, being the order under challenge, 755 of 2024.
It is only up to 11 pages.
একটু আমাকে দিন না, কারণ আমরা বের করে দিই।
এটা my lord কে দেখে দিন।
না না, পেজ 35 দেখাতে হবে। যে অর্ডারটাকে আপনি রিভিউতে এসেছেন, সেই অর্ডারটা কোথায়?
এই তো স্যার পেজ 35।
We don't know from where you are reading page 35. We don't have 35 pages.
এই কপিটা দেখুন।
রিভিউ অ্যাপ্লিকেশনটা কোথায়?
Your review application
দেখে দিন
is.
My lord, this is the page, my lord.
No, we don't want to see from your brief. Why have you not paginated the court's brief? This is the way you will assess
This
the
is not
court.
my appeal, my lord. This is not my application. This is his application.
What is this?
My lord, it is a transfer brief, my lord.
So nobody has responsibility.
No, my lord, I tender my apology, my lord. My lord, it is annexed in the memo of appeal, my lord. The order, impugn order which is challenged, my lord.
Memo of appeal.
Memo of review, my lord. Memo of review.
What is the date of the order?
My lord, the date of the order is, my lord, 25/06/2008, my lord. This is the impugn order under review, my lord.
Yes.
My lord, now coming back to page 19, my lord, the order, the operative portion, page 21. Page 21. Coming to the question of disbursement of pension and other retiral dues, it is submitted by the appellants that they have completed the formalities and submitted the documents. If there is any deficiency, it to be completed within a period of 15 days. Let the permissible amount of pension and other retiral dues be finalized and disbursed within the outer limit of 2 months from today. Now, my lord,
Appeal is disposed of. Then what remains in the.
My lord, now we are before your lordship in the review application. Because of that, our retiral benefit is not being disbursed, my lord. That is why this is prayer before this honorable bench, my lord, to dispose of this review in terms of this order, my lord.
What in terms of? It is infructuous.
my lord, absolutely.
My lord, but my lord, if I do not get my review
It is
retiral
submitted-
benefit, there will be a limitation, my lord.
Submitted by the
check to compliance of the formalities, my lord.
My lord, only one line, my lord.
We are ready
you
to
saying? We
disperse the
don't
amount.
My lord,
There is no issue.
kindly appreciate, my lord, he's submitting, my learned friend is
What are
submitting.
you saying?
My lord, my only prayer is this, my lord. If I go for my retiral and if they say that there is a limitation, it has to approach the honorable tribunal, my lord, that this limitation point will come, my lord. Only one line, my lord.
So we have said in terms of the Supreme Court order. What more can we say? We have recorded the date of the order, the case
That part
number.
is covered.
Yes.
Grateful, my lord.
Grateful, my lord. Thank you, sir.
Item number 3.
Item number 3, my lord, I am for the petitioner, my lord. On the last occasion, there was a direction, my lord, to serve notice upon the respondent, my lord. We have served, but my lord, the affidavit service, but my lord, the service is not completed. We need some more time, my lord.
As paid by learned counsel for the
Item number 4.
Lord, in this matter, will I appear for the petitioner, Union of India. Now, my lord, the order of the learned Central Administrative Tribunal has been impugned in the present writ petition. The writ petition was stood dismissed for default, but after filing restoration, it has been allowed. Now, my lord, I have been recently briefed in this matter to place argument, my lord, in support of the writ petition. Now, my lord, thing is this, my lord, we need to serve the other side. The matter has come up before your lordship suddenly. So we need to serve the other side. Your lordship
has come up before us suddenly.
No, let it be hard, my lord.
You are saying it has come up
It was
before us
not
suddenly.
We did not take any steps to get it mentioned before your lordship.
Now we are telling you on 5th December.
It was mentioned.
It was prayed by the learned counsel for the petitioner to list this matter on 2nd January, and he has stated that he will intimate the next date of listing to the counsel for the respondent. And you are saying it has been listed suddenly.
No, I'm sorry, my lord. I stand corrected, my lord.
You do,
In
sir.
fact,
You do stand corrected.
Yes, my lord.
Just have a look
I'm
at the
extremely
order.
sorry.
Yes. Then,
So we shall serve, my lord. Let it be after 20th, any day, my lord. We shall.
as prayed by learned.
না করে নিচ্ছি এটা তো
Item number 5.
Lord,
Yes.
Lord, in this matter, Lord, I appear for the writ petitioner Union of India. The thing is this, Lord, the blood respondent has already expired, Lord, during pendency of this writ petition. Now, Lord, on the last occasion, Lord, your lordship pleasure to direct on 4th December, if your lordship sees the order, to Lord, bring the Lord substituted respondent by way of an application. But Lord, the wife is there, Lord, if your lordship directs, Lord, we can substitute the wife only, because the incumbent who has the service
You are
holder.
appearing on the last day.
I did not appear. Lord.
Every day something new cannot be done. There
There
should be some continuity in your submission.
Yes, Lord, we are informed by the Learned Counsel appearing for the Petitioners Union of India that the private respondent has passed away in July 2023, and that they would be taking out an application for substitution. Let the same be done positively within 2 weeks from date. Now, Lord, who would bring out the application? That is the whole question, Lord. Because the respondent, it is the requirement to file an application for substitution by the respondent. The respondent has passed away.
In your writ petition, the respondent will file a substitution.
That's correct. Our writ petition, but
You file a substitution. You have said that within 2 weeks you will do it, and now you are saying something else. That is why we are saying there should be some continuity. This cannot be done every day.
I understand.
Another counsel will come and another submission will be made, then nothing will ever be finalized by the court.
I understand what
The order was positively within 2 weeks. Means nothing to you.
कोई की पे But, in any case,
At least you should go through the order before you come to the court. This is not the place where you do this.
I understand, Milord. I am sorry, Milord. In fact, Milord, we received instructions with regard to Milord, the Milord, legal year of the respondent. So, Milord, we need to add them by filing Milord, substitution application. Milord, I am seeking Milord, extension of time. Milord, from your lordship. I am seeking extension.
You do it by within 1 week. Time is extended for filing substitution.
Grateful.
Yes.
1 week এর মধ্যে করে দিই ফট করে ওদের সঙ্গে কথা বলে করে নিই আমি গ্রেটফুল
Item number 6.
It's not appearing. Today again, there is none to represent the petitioner. First, second, third, fourth, fifth. Sorry. Fifth.
Lordship, item 7, your lordship.
Item number 7.
Item 7, your lordship. I appear for the petitioner, your lordship.
Yes.
Your lordship, due to a grave personal difficulty, your lordship, I'm seeking some short time, your lordship, to do this matter, your lordship.
Yes, it will come on 29/1.
I'm so grateful to your lordships.
Item number 8.
I beg to appear, my lord.
That's one.
My lord, the crux of the matter is whether the past service under contractual capacity or temporary capacity be counted for pension or not. That is the issue here. The petitioner initially appointed as a contractual employee and he served a sufficient time for the department.
What is the length of service
My
that
lord.
you want to be counted?
Total service length is 15 years, 13 months, 27 days.
We are
Out of that,
Yes.
7 years, 6 months, 12 days at contractual and 8 years, 7 months, 15 days is permanent. If my contractual period is
So
added
this 7 years starts from which date? What is the
first
date?
7 years she started on 5th November 1999 to 5th November 1999 to 16th May 2007.
So you were regularized in 2007.
17th May 2007.
17 May 2007. Where is the regularization order?
Page 95, my lord. Page 95. 5th March 2008, the order and effect given on and from 17th May 2007. And my lord, kindly mark one line, that is last part, one paragraph.
Please, we are trying to read.
My lord.
We are trying to read.
My lord.
8 March 2008. Thank you.
95.
Okay. Hmm? 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 It will be with the statement, that's it. आगे तो 2013 से 2023 में हुआ
Why have you challenged the order? How are you aggrieved by the order?
Aggrieved, my lord, in the sense that 2 times my faith was tested by the authority. Again, the tribunal, without taking the decision, although the law has been settled by this honorable court, the another coordinate bench law has been settled. The tribunal again sent the matter to the authority. Initially, my lord, while I was in service, I made several requests to the authority, and during after my retirement, after my superannuation, the authority took a decision. I am not entitled to get the benefit. I challenged that order before the tribunal. Tribunal set aside the order and remanded the matter again to the highest authority of the department. The highest authority again again turned down my prayer by invoking a wrong rule of TCRB, which is not applicable to me. Thereafter, that order has been challenged before the tribunal, and before the tribunal, I placed the law, which is already been settled by this honorable court. But without taking any concrete decision or mandatory decision, my lord, the tribunal again sent the matter to the authority. That is the problem, my lord. That is why I am aggrieved. If your lordship find your lordship's record, then lordship will find one judgment I already placed before the another coordinate bench, that is Nimai Chando Chat. No, already Dawaj. Kindly consider the judgment of Nimai Chando Chatterjee. My learned senior friend was there. Dawaj judgment. Oh.
That is judgment of yourself. Nishita Matre.
And that judgment subsequently confirmed in another judgment.
My lord interpreted this.
Vastudev Shina.
Where are these two judgments?
Matter already in record, my lord. Nimai Chanda Chatterjee.
What does it say?
That I am entitled.
You are entitled to what?
I am entitled to get pensionary benefit by counting my part service on contractual capacity.
The service during contract period is required to be counted. You have given only one copy.
No, my lord, 2 copies. Given.
Yes.
Although, my lord, I can.
No, your lordship, this court interpreted Rule 36 and Rule 41A.
Rule 36 is different, my lord. That is in case of shortfall. I am not on that.
Then which provisions of law he will get entitled pension?
That is already decided in the Nimai Chanda Chatterjee.
Nimai Chanda says is different.
No.
Let us see.
Just pat on the point. Rule 18 and 22(1). কোনটা গো? নিমায়ের? আপনারই তো করা।
শিখে আমার কাছে আছে, ফিল হয়ে চলে গেছে এটা রেখে।
পুরোটা আছে কিনা দেখি। পুরোটা তো নেই দাদা।
এই যাবে ওটি আছে।
CHM না? CHM, 3 CHM. এশিয়ান করা আছে, দেখ এশিয়ান নেই।
So we have to see rule 17 of DCRB.
My lord, that I have annexed in my supplementary application. My lord, kindly.
And we have to see the memo dated 22/3/1973.
Both the provisions I have annexed in my supplementary application. Hello, kindly take up the supplementary application first.
Rule 17.
My supplementary application, page 26. DCRB rule. My lord, got?
Rule 17, my lord.
Acha,
He has annexed it.
My lord, kindly take table to come, page 26.
Page 23.
26. 26, my lord, 26. No, supplementary.
To the page 52.
Yeah, ওটা আমার না। আর কি এনেছে রিপোর্ট আপনার নিজের জিনিস।
No, supplementary order দেখলে।
রিসিভ করা আছে।
কে করেছে? কে করেছে? কে করেছে দেখতে?
আপনাকে দেওয়া ছিল সাপ্লিমেন্টারি স্যার আপনি চেক করে রাইট করে
And memo 22/3.
Memo, my lord, that is page 12 of my supplementary. No, that is 17th March 99 memo, my lord. My lord is asking for 17th March 1999 memo, my lord.
22/3/73.
22/3/73.
Is at page 5 perhaps, just see.
Yes, my lord. Page 5. সব দিয়েছি দিইনি বললে তো হবে না, আমার অ্যাকসেপ্টেন্স আছে কি করে বলেন এটা দিইনি।
না কে সই করতে দেখতে? কে সই করতে দেখতে? ধরতে পারবো।
আপনি তো করেন, আপনি কি সই করেন?
না না
তাহলে দেন
কি না কর
দেন
অন্যকে কাকে দিয়েছে? কাকে দিয়েছে কে দেবেন? ও দুনিয়া সই করছে। কে দেখতো নামটা দেখতো, কে নামটা দেখতো? দেখ না সই করা দেখ তার নাম।
তপন মুখার্জি লেখা ও না
তবে এটা নাই না আমার কেউ নেই।
না না তারপরেও কপি দিয়েছিলাম আমি এর আগের দিন তোমায় কপি দিয়েছি, ডোন্ট সে দিইনি, এক্সপিআর কপি ছিল সেটাও দিয়ে দিয়েছি।
So prior to your regularization, you were working as?
Contractual, my lord. Page 91, my lord.
Yes, it is. Seven. Is it applicable to? In these regulation?
কিছু না রুলগুলো দিয়েছি শুধু নতুন কিছু রুলগুলো আপনাদের মেমোগুলো দিয়েছি Page 91 is, my lord, first my appointment letter. Page 91.
What is page 91?
Page 91, first appointment letter by which I was appointed as contractual basis. And most surprising thing is, my lord, on the time of taking the seniority, in case of promotion, they were counted the per service, not on the time of retiral benefit. If your lordship
Now, kindly see, page 145 of the repetition. When the matter was considered by the Director of Health Services. After detailed discussions, he has come to the conclusions there is a shortfall of 1 year something. And when
9 years, 9 months, 30.
9 years, 13 days.
9 months and 13 days.
Sorry, 9 years, 9 months, 13 days.
Shortfall.
And shortfall.
To attend the 10 years of.
Attend the 10 years. And when this rule has been amended, in 2009.
কি বলে গেছে কেন? DCRB?
147.
This is the notification of 25th February 2009. I've got a copy of the notification, only one copy.
146.
Which you think if the government may condone a deficiency of 6 months qualifying service of a government servant. The petitioner Haradan Mahato in the petition number has rendered service under the government, but admissible service period was 9 years, 9 months and 13 days. And the shortfall period to attain 10 years of eligibility was well within the zone of 6 months condonation levied by the government. But in this case, shortfall of Kamal Company attain 10 years service appears to be 1 year, 4 months, 15 days. To attain 10 year eligibility and very much more than 6 months service. That Haradan Mandal has been distinguished or factual aspect. Now understanding view that as the applicant, original applicant number such and such, Kamru Poli means shortfall 1 year, 4 months, 15 days to attain 10 year minimum qualifying service to obtain pensionary benefit, and this period of 1 year, 4 months, 15 days shortfall being more than 6 months maximum period condonation of shortfall. To condone the deficiency of quality. Yes. On a finally see page. That is one.
Page 118.
141. 141. 141. Ends at page 143. Munad, can you see? I'm going to rule 36.
Seeking conservation or in seeking out services rendered under the
page 143, that the delay in issuing the formal office order regulating my service cannot be deprived me from enjoying the benefit of usual pension and retired benefits on the ground that I did not complete 10-year service period, which is actually not correct in view of the fact admittedly from office record that date of joining of service on 5 November 1999. How it could be 5 November 1999? The benefit of usual pension and gratuity would not be denied to me on alleged ground that I did not complete 10 years service before retirement on the attaining the age of superannuation. On page 143.
The last paragraph,
Oh, sorry, 140. That due to delayed issuance of also complete period of service superannuation 16 years, 1 month, 26 days, which is also made more than the period of required for pension. Next, madam. That the total period of my service should not be altogether ignored and counting of his service. No, then whether he should be. No. No.
So the tribunal has said whether his service rendered on this.
Yes.
There's no issue of knowledge.
Yes.
Attitude does not come in.
Yes. Kindly see rule 17.
Yes, we have just seen.
Yes.
Come to page 36 supplementary.
Rule 17. Qualifying service. Subject to the provisions of this rule. Qualifying service of a government servant shall commence from the date he takes charge of the office of which is first appointed either substantively or in the officiating or temporary capacity. Has he fulfilled any of the conditions? Kindly see the language. Substantively or in officiating or temporary capacity. But he has never appointed temporary, casual employee. He was a casual employee, he had confirmed in service, a regular service in 2007. No matter if the judgment has to be read in the factual aspect. Yes.
Was that in that case he was appointed as a temporary. Now come to page 14. In fact, in this case, see paragraph 2 and 4. They were appointed on different dates as single vendors.
Petitioner. But can you see the language page 2, second paragraph?
Yes.
The petitioner discharged the same duty continuously without any interruption or. Yes, sir.
The court has recorded the opening line of paragraph 2.
Yes, sir.
The petitioners in this case were temporarily occupied as signal vendors on different dates.
Yes.
Is the question of any kind of temporary appointment? Not there.
Kindly see the order recorded in by the Director of Health Services. No. Whatever will be written on factual aspect.
Temporary basis.
What the director has written.
Yes.
At the third paragraph, actually, also. And
whereas it appears that the applicant contended in the original application that he, in terms of the advertisement,
here
was.
these were at least appointed after an advertisement.
Yes. No.
They were appointed on different dates.
In terms of the advertisement was initially appointed on 5th November 99. Yes. As MTECG under the State Health Development Project Southerners as contractual basis. Kindly language the contractual basis. On consolidated monthly remuneration in terms of the scheduled payment and was posted at Diamond Harbour SD Hospital. Consequently, he had worked continuously from 15 November 99 till 16 May on contractual basis. Kindly see. Therefore, pursuant to the order by debtor, 5th November issued by the then head director, his service was regularized with effect from 17 May 2007. Right. If somebody works in a contractual basis and subsequently he regularized, then the post has to be created today. If I give him the pension, temporary rate, there is no post.
The post has been created in May 2017.
No, the post has been created 17 May 2007. Sorry. And 7.
So till May 2007 there was no
Post. He was a casual employee, contractual employee. Can you see the language? Contractual basis. As soon as the post is sanctioned or approved by the government, normally we because we prior to Umadevi judgment, when they would have but one condition is there in Umadevi's case. most probably 93 or 94, that 53, there must be a sanction for. But we have regularized. But there is no difficulty. Regularized means what? We have given appointment. Appointment when? On 17 May 2007.
After
That means-
Madhavi. After Madhavi.
No, it may be that at that time, Uma Devi notifications were not set aside by the High Court. By Justice Pratap Chandra Rai.
2005.
No, but after Madhavi judgment came into force in 2006, Volume 4, 1 SSG, 10th April 2006. But circulation of the judgment and one impact of the no, was issued by the Director of 17 May 2007.
No. That is effect. March 2008.
No.
এই যেটা বলছি, there are the percent order by যেত,
5th March 2008.
that pursuant to the order.
That pursuant to the order number dated 5th March 2002, issued by the State Director Health Service, service regularized with effect from 17 May 2005. Yes. But I'm not, but when he has been regularized, we cannot raise an issue. No, but my limitation is there. We cannot go beyond the records. Kindly see the language.
No, we don't want to see Rule 17 you have placed. Don't do that again.
No.
We are asking you, temporary employee has been defined in DCRB.
Kindly see the definition clause. Emolument.
Is there any definition?
No.
It's not different.
Rather, my lord, the memo of the
Not, if this is not defined in the, but it can be imported in the statute. I'm putting the question to myself.
You are the framer of the statute, sir.
No,
And not the petitioner and not the court.
but then why? Rule 36 has been,
You are doubting your own statute, then we don't know what.
but executive will go bound the rules. They
So
cannot go
temporary, there is no definition of temporary.
temporary. But contractual basis and the
Contractual has been defined.
contractual has no also been.
We know, we have gone through, therefore we are asking. So these word use of these words has to be appreciated in the context of every individual claim.
Yes.
And for some guidelines, we are bound by this coordinate bench. They have considered what is a temporary employee.
In my submission, the fact is different. Factual.
And that you have submitted.
Yes.
Let us. Yes, come. Or learned counsel for the petitioner.
accepting that the railway authority would be at liberty to proceed with the second selection process, but they would not be entitled to publish the result. My lord, we were not satisfied with that. We came before your lordship's court. My lord, 2014, my lord, ultimately, my lord, all the writ petitions, bunch of writ petitions were taken together, and ultimately our rights were recognized, and my lord, we were directed to be appointed. Now, my lord, the moment we were appointed, after that, my lord, we filed an application seeking, my lord, that the pensionary benefit would be granted to us from the date, my lord, when this our right, my lord, accrued. My lord, we were not sitting on the fence, my lord, and watching the show. We immediately approached before your lordship's court when our right was alive. So, the ultimately, my lord, page 73, subject to correction, my lord, the order was passed against us saying, no, this cannot be done because you are covered under the national pension scheme. The regular pension schemes cannot be given granted. Be that as it may, my lord, all these starts, my lord, came to favor us, my lord. The central government took a decision that no, the pensionary benefit will be given to us in pursuance of the earlier rule, 2000, before, not the NPS. Be that as it may, my lord, we are covered. Now, the only point that was left to be decided by the authority that whether we are entitled to get the benefit as a notional benefit, my lord, on and from the date, my lord, when, my lord, we participated in the selection process, or on and from the date of the selection process. Now, my lord, this question, my lord, answered in the negative by the tribunal. The tribunal said, my lord,
which benefit from that?
The benefit, notional pensionary benefit, we are covered under the pension scheme. Today, there is no quarrel with that.
So the fixation of
the
pension,
fixation of the pension notionally, my lord, on and from the date when our right were accrued, rather when I came before this honorable court. We came before this honorable court, my lord. The advertisement was published between 8th to 5th, 24th, 14th February, 1997.
you came in 98.
I came 90.
To the tribunal in 98.
1997. আমরা এসছি কবে 1998 তো না না ফার্স্ট no to first application I to stand correct in 1999 after 2 years. So when 1998 I came to know 1999. Millard, there was series of Millard conversation between the Millard in this long-standing Kurial combat, Millard, that ultimately records were burnt. Now, Millard, it could not be traced out. High Court Division Bench, Millard, graciously interfered with this, and because of the inherent generosity of the High Court, Millard, in discharging, Millard, dispensation of justice, Millard, ultimately we were appointed in the evening of our life. Be that as it may, Millard, the long time, Millard, had passed, 1997 to 2014, Millard, kindly considered. That means, Millard, 1999, that means, Millard, selection for 14 years in a way. Now, Millard, ultimately we got a job. Now, Millard, today the authority said, no, this cannot be done. The tribunal, Millard, the government, Millard, finds favor with the observation by the tribunal. Tribunal, Millard, says, no, that they are correct because your, whatever may be the date of your filing of your application, but the date of appointment that was granted by the Honorable High Court 2014, the High Court was silent about the date of all other benefits on and from which date this was never fixed at the High Court. The question is, Millard, today, at that point of time, that the point of law that was posed before the High Court, whether in that, Millard, conspectus of facts, whether we are at all entitled to be appointed, even though, Millard, our name was appearing in the panel, or whether we are unsuccessful, that was in the amidst of uncertainty. High Court, Millard, ascertained, Millard, the fact. By reason of its interference, the railway authority also had, Millard, lent meaningful assistance at that point of time. Initially, it was not there, but ultimately, when the records were placed before the High Court said that we are entitled to be appointed. So, we, on the day, Millard, because, Millard, your lordship, Millard, kindly, Millard, have the charity to consider, when I came before your lordship's court, Millard, which ultimately disposed of, Millard, the WPCT in 2014, at that point of time, there was no issue before the High Court, and it was not known to us as to whether, Millard, what kind of benefits first, I was not sure about that why it was cancelled. I was not sure about, Millard, that what is, Millard, the position of because the entire records were, Millard, destroyed. Be that as it may, the points, Millard, the question is my entitlement. Millard, in many matters, Millard, the court granted relief to the plaintiff or the petitioner on and from the date, Millard, when he came before the court. It is not a case, Millard, I did not join, but I claim benefit. I am not saying retrospective when all financial benefit when I did not work. I said that for the sake of clarification, Millard, I said, and I submitted before the authority, that I was prevented and no fault is attributable to me in any manner whatsoever, because the selection process that was ended abruptly, it did not allow me to join. Ultimately, because of the judicial interference, I was allowed. When my right was recognized, it should be recognized on and from the day, my lord, I came before the court.
What is the date of the order of 2014 passed by this court?
29th January 2014. 29 January 2014.
This is passed in WPCT.
WPCT.
Number?
Number 53 of 2008. 2008.
2008.
And another is, my lord, the other batch, WPCT 722 of 2007. We are, my lord, on. We were clubbed, my lord, in WPCT 722 of 2007.
The earlier one.
Yeah, the next one, page 31.
Yes, 722 is the earlier one.
Earlier one.
Yes. So you are in now at the time of disposal. These matters were disposed of after the order of appointment was issued or directing for issuing?
Directing for issuing the appointment.
And when was the appointment order issued?
Appointment order, my lord, that is page, my lord, 33, 27th March 2014. Page 33, 27th March. Provisional appointment, my lord.
So let us see the order of 29/1/14.
That is, my lord, it starts from, my lord, page 27 of your lordship's brief.
Your lordship, kindly accommodate me, madam. My junior advocate on record as ill. History has not come to court, madam. Any day, madam, your lordship fix, madam.
Till 20th, we will not be available.
21st, 22nd,
anyway.
any day. A date could have kindly give a date subject to.
As prayed by learned counsel for the respondent.
Item number 10.
No, I am for the petition in this matter.
Respondent led by Mr. Sovik Nandi. Sovik Nandi is not come today because due to his illness.
No, this is the matter.
Not this week.
Your lordship knows from 2010 notification we are not getting the job. In spite of the several order was passed by this court.
In opposition.
Yes,
You have filed it.
Yes.
I have applied.
No, I have seen that reply is not necessary. All are the rules. They have stated.
The affidavit in opposition being filed by the
Item number 11.
Your Lordship, in item number 11, Your Lordship, my humble submission is that the cause papers have been misplaced, Your Lordship. We have asked the department to supply us the cause papers. Your Lordship, kindly make this matter not this week, Your Lordship.
Private respondent. Only one respondent.
Last occasion, it was submitted that the SG will be appearing in this matter.
Your Lordship, he is appearing in this matter.
So in spite of last adjournment, you have not been able to get the cost papers. This was on 4/12, 1 month back. I mean, still today you are saying you don't have the cost papers. Very casual approach. And how can you say that you don't have the cost paper? Your department does not have any cost papers.
Your Lordship, they
1
have.
month has not been enough.
Your Lordship, kindly accommodate me for 2 days' time, Your Lordship. This matter could be taken up on Monday, Your Lordship.
We are informed that the Leonard ASG
Item number 12.
Well, 12 mile, I am for the petition. Well, during the pendency of this case, my lord, the interim relief I prayed for before this lordship. And during the pendency of this case, my lord, the learned tribunal disposed of this matter. So the fresh cause of action, lordship kindly dispose it of, and in
Liberty.
terms of the order, liberty to file fresh application.
It is submitted by the Leonard's.
And your lordship kindly give liberty, my lord, to my fresh challenge.
You don't listen to the order. Reserving the petitioner's
yes,
liberty. We have.
Same, my lord.
Next case.
Next
same.
matter, same.
Very good. Just check the case
Identity.
date and case number.
Yes, sir.
That will vary.
13.
Date and case number will change. Date and OA number.
Liberty দিয়েছে? Liberty দিয়েছে? ঠিক আছে।
13.
13 হয়ে গেল।
Item number 14.
My lord, in this matter, I appear on behalf of the respondent.
Appearing on behalf of the appellant lordship, this is my application.
Which of these people has preferred the appointment?
State of West Bengal.
Has preferred.
We have preferred this appeal. Lordship, in the last occasion, lordship, there was a direction to file the affidavit in reply, lordship.
I'm filing my affidavit in opposition also.
Reply.
Position.
Lordship, I'm being led by Mr. Mali.
Just we are reading the order. Just
Lordship.
এটা হচ্ছে জাজমেন্টটা যেটা বলেছিল 19 নম্বর প্যারাগ্রাফ। এটা আচ্ছা ফার্স্ট দুটো তিনটে জিনিস এগুলো নাটশেলের করেছে রিপ্রেজেন্টেশন মা দিল 2 বছর বাদে 2003-এ মারা গেছে যে 21-এ 12
Yes. Now, my lord, so far this case is concerned, my lord, it's a basic case of compassionate appointment. Now, my lord, what happened, my lord, is, my lord, the petitioner's brother, the brother died on, my lord, 2021. Sorry, my lord, 2001. I'm sorry, my lord.
Second.
2001, he died, my lord. Thereafter, my lord, in 2003, my lord, his mother has made an application for compassionate appointment. Now, my lord, the
brother has
mother, my lord, made an application for compassionate appointment, initial appointment
in 2003.
Now, my lord, lordship knows, my lord, the basic ingredients of compassionate appointment is, my lord, to give 2 square meal to the family when the bread earner has died suddenly. Now, here in this case, my lord, the brother is died. Now, father is a government employer. And not only that, my lord, the brother is died, my lord, in 2001 December. Now, after 2 years, my lord, her mother, my lord, has made an application when she has received the terminal dues, whatever dues is there, my lord, on account of the death of that young person, my lord. Now, my lord, thereafter, my lord, the brother made representation, second representation is in 2004. So, my lord, there is a gap between 2001 to 2003, then 2004, 3 years. Now, my lord, if he made an application there, then and there, then the situation was otherwise. Need is there. Now, my first and foremost submission is, my lord, where is the basic ingredients of compassionate appointment? He is not the father or the mother. He's a brother.
When he, no, but he is entitled under the scheme.
No, at that point of time, my lord, it says, my lord, page 21 of the judgment, my lord, kindly, may I just read, my lord, the state respondent in reply to the case of the applicant had taken the plea that the applicant was not solely dependent on the deceased employee because his father, Birendranath Ghosh, was a retired employer of group D staff of the Office of District Physical Education and Youth Welfare, Nodia, was alive and drawing pension at the time of elder brother of the applicant died. It is stated in reply of the family pension of the deceased
Where
government.
you reading? From where you
Page
reading?
21, my lord.
You said judgment. Which
No, my
judgment?
lord. Page 21,
Page
lord.
21 is the order.
Is the
Judgment
is
of
the
Page 21 of?
Administrative Tribunal.
21 of the, my lord, application, my lord.
This is the order rejecting his claim.
Lordship.
The first order.
First, this is the first order, my lord, passed by the tribunal.
It has been rejected twice, or it has been
Twice.
First order was rejection, which was the mother's
First
application.
was, my lord, the mother's application. That was rejected. This is to info. That is at page 19, my lord. This is the mother's application in 2003. It was rejected, my lord. In 2000 and, my lord, page 19, my lord. This is to inform you that the opinion from the Labor Department, order number so and so, in the instant case, the deceased employee had no family comprising son, daughter, or wife, and so there should arise no question of considering appointment on compassionate ground in favor of his younger brother.
Page 18.
Page 19, my lord. 19, my lord.
In regard to the
18 টা, my lord, বলছে।
18 টা affidavit এর পাশে।
Oh.
Affidavit এর পাশে, page 19. হ্যাঁ, পিকচারটা এটা হলো এটা
This employee was an unmarried person.
Yes, my lord. That has been.
এখানে এখানে এটা আমাদের আছে এটা হচ্ছে এই নোটিফিকেশনটা যেখানে বলেছিল সান ডটার নিয়ার রিলেশন এটা আমরা মা বেঁচে ছিল মা বেঁচে ছিল দেয়ার আফটার দ্যাট
But this is of 2007.
My lord.
Page 19 is of 2007.
Lordship. 14/8/2007.
Yes.
That was a rejection, my lord. In 2003, she has made an application.
It took you 3 years to consider it.
That's, my lord. That is, my lord.
Yes. Because he had no family.
No
He had
family.
No son, daughter, or wife.
Lordship. Lordship.
So he was unmarried.
Lordship.
Yes.
And in the affidavit, lordship, in the last earlier page, my lord, I have shown to his lordship, my lord, the observation of the my lord, tribunal.
No, where is this Labor Department order?
Yes, my lord. May I? এটা তো
লেবার ডিপার্টমেন্টে কোন অর্ডার
সার্কুলার লেবার ডিপার্টমেন্ট এইটা যেটা বলছি
27/9/2006.
Yes, my lord. This is the
সার্কুলার আমি আরেকটা পাতা দিই
আর পাতা আছে
আছে
my lord, I have one copy, kindly excuse me.
না না
আমাদের
কপি
আছে
আছে দু কপি
my lord, sorry. ওই লেবার ডিপার্টমেন্টের 97 হ্যাঁ 30 অন্য আছে তো
কপি সেকেন্ড পাতায় আছে বলে
হ্যাঁ
বলে দাও না ভাই কপিটা সেকেন্ড পাতায় একটা পড়া যাবে
এটা
কপি সেকেন্ড পাতায় আছে এটাই সেম জিনিস আমি দিয়েছি
the typed copy in the second page if lordship so my lord is eligible. I'm sorry, my lord.
এরপরে আমি এখানে কি বলবো এটা আমরা দেখালাম আচ্ছা এইখানটা দেখাবো consider the application of compassionate ground in view of the law. এটা কি বললো এটা বললো ওর মায়েরটা আমরা রিজেক্ট করলাম মায়ের এটা তারপরে আবার তুমি দেখাচ্ছ কনসিডার করতে হবে, কনসিডার আমি পাস আর রিজন অর্ডার আমরা করলাম, কনসিডার করলাম, রিজন অর্ডার পাস করলাম। এখানে এই জায়গাটা
But this prima facie it is unsustainable. It says because he has no son, daughter, or wife.
Lordship.
But this says son, daughter, or near relation.
Now, my lord, if his lordship take the analogy of near relation, mother and father is alive.
No, but this order does not take that into consideration. This is only on the point that no son, daughter, or wife. You don't say that their near relation who should have come has not come. That is not the consideration.
But so far compassionate appointment is concerned, my lord, it's a scheme. It's a scheme, my lord.
And this is the guiding for the scheme.
Yes, but my lord,
this covers the claim.
But my lord, the question comes, my lord, that within time or not within time. If
No, but that is also, this is not the rejection. What is not there in the order, you cannot argue. The argue is only the order is only because he is neither son, daughter, or wife.
Yes, my lord.
That is unsustainable. From a bare reading of this, it is apparent. You could have said that he is neither son, daughter, wife, nor a real near relation entitled. The committee was required to inquire whether there was such hardship.
We have inquired, my lord.
But this order doesn't show anything.
My lord, we have inquired. We have inquired, my lord. If lordship take page 21 once, my lord, the judgment, my lord. My lord, kindly see, my lord, in the
Page
second
21
of the judgment, my lord. That is the writ petition, my lord. Page 20 of the writ petition, my lord.
273 of 2012.
Lordship,
Yes.
lordship.
Yes.
Lordship. In the my lord, in the second paragraph, may I just read, my lord?
Yes.
In short, the case of the applicant is that Bijoy Kumar Ghosh, the elder brother of the applicant, died on so and so in a road accident while serving as constable in the West Bengal Armed Police 1st Battalion, Barakpur. Mother of the applicant made a representation before the commandment, State Armed 1st Battalion, Barakpur, here so and so, praying for appointment of her son, that is the applicant, on compassionate ground. The applicant was submitted a duly filled up prescribed forma before the appropriate authority. An inquiry was conducted about the genuineness of the claim as well as the financial condition of the family of the deceased government employee, and a report was placed before the respondent number 4. Ultimately, the authority concerned rejected the prayer of the applicant for his appointment on compassionate ground only on the ground that the deceased employee had no family comprising son, daughter, so and so. That has been stated. So, my lord, thereafter, my lord, in this specific case, my lord, the Labour Department circular I have shown to his lordship, the state respondent in reply to the case of the applicant had taken the plea that the applicant had not solely dependent on the deceased employee because of his father, Birendranath Ghosh, is a retired employer of the government of West Bengal, and it is also in reply to the family pension. Now, my lord, and when the mother was alive. Now the skip over the last page, my lord, at page 23. Accordingly, we set aside the order under challenge with a liberty to the respondent, in particular the respondent number 4, to consider the application for job of compassionate ground of Ajay Kumar Ghosh in view of the Labour Department so and so dated so and pass a rescind order after taking into consideration the scheme of compassionate appointment and the criteria to be fulfilled in such a case without delay, preferably within 6 months, and communicate the decision to the applicant within 1 month thereafter. The mother of the disease is still alive.
No, that is immaterial. If she was objecting that no, don't give it to him because he will not maintain him, then you may have said something like this. She has asked for his appointment. That is not something rare. It happens all the time.
Now, my lord, lordship knows, my lord, that compassionate appointment is not a matter of right or a matter of
That
choice.
is a different thing, but you are bound by your own scheme. You cannot act arbitrarily. But you cannot assign a reason which is not sustainable.
Now, my lord, so far that scheme is concerned.
So what happened after this order?
After this order, my lord, in 13 of September. 13/1/2015.
Page 24.
Page 24.
Please let us read.
Lordship.
Oh, so this also this is also recommending to give him the employment.
Yes, proposal. Considering the facts, government may move with the proposal to give employment. Proposal was exempted category subject to observance of relevant condition and formalities as per rules.
Yes.
It's a proposal. It's not a recommendation.
Correct,
Direct
correct.
recommendation.
It is probably the committees or oh, this is his controlling authority.
Lordship.
No, but above that, a committee was formed consisting of 3 members, and the committee submitted a report on 13/8/2004. Opined that this case may be considered for appointment under exempted category. This is the recommendation of the committee. Where is that recommendation? 13/8/2004.
Recommendation.
So everything has been examined by your committee, and then committee has recommended, and therefore the controlling authority has said that government may be moved to give him employment.
But so far the first recommendation is concerned. Thereafter reject. After 5 years, my lord. Kindly appreciate that also, my lord.
Your committee.
Yes.
Where is that committee's report? 13/8/2004.
I don't have that. My lord. Earlier also, my lord, I sought for because it's old case, my lord.
Whatever it is, this is the finding of the committee, and this is to in favor of the
May I just
petition.
give 1 minute.
What is exempted category? What is exempted category?
Exempted category, my lord, there are categories, my lord. Suppose, my lord, a land loser or, my lord, a freedom fighter. These are the persons.
Where is that? For my sake, I would like.
Then I shall bring all those, my lord.
Please come with that.
Lordship.
This is, I have not seen a case of this like earlier. Therefore, I am asking.
Lordship.
My brother may be aware, but I am not aware.
No, I shall definitely.
But there is no dispute to that they had proceeded to.
No, that we have seen. We want to see what it is. We want to see what it is. Have you got this? Where is the exempted category specified?
Well, that
You are a beneficiary under the exempted category.
Correct.
What is the exempted category? Show us.
I shall place that. I don't have.
That is what he is saying. You are arguing. We would like to see, because the committee has considered you to be a beneficiary under the exempted category. We don't know what that category is. We have not seen it. Is it here? Is it in the? It's not in the file.
No.
Because the point of delay, if you are raising the issue of delay, that of course, since the matter is continuously being pursued, it happens many a times.
No, my submission is that the initial, my lord, the application. Maybe, my lord, matter may be dragged for a period, my lord. That is not the case. The case is, my lord, the person died in 2001. Now, if the family is so need of money, my lord, a compassionate appointment, my lord, then he could have come within a month or 2. Instead of that, my lord, they have chosen to silent over this issue, and after 2 years, my lord, they have made an application.
Perhaps
The tribunal has directed you to consider.
It has reached its
You
final.
have embarked on a consideration exercise. You have not raised any objection. Your committee has made a recommendation. Now can you be permitted
Yes,
to
updateful, my
Now,
lord.
my lord, now,
go
my lord,
back to that position? Now the clock cannot be turned back. That was the opportunity.
Yes.
If at all
But
you
in
wanted
fact,
to
my
object,
lord,
my lord,
they have not challenged the parent.
have we asked you anything? Yes.
my lord, now, my lord, now, my lord, now, my lord, thereafter, my lord,
We don't know
in not
whether
only
you
that,
can-
in 2020, my lord, also, my lord, there is an order, my lord, passed, my lord, in page 25, my lord, if lordship takes 25 once, my lord,
25
of the, my lord, writ petition. No, no, the iPad is. At that point of time, father was alive, my lord.
Still alive.
And mother is still alive.
Receiving a pension.
Yes, my lord, now, yes, family pension. But father was alive at that point of time, my lord. Lordship. My lord, I shall, my lord. Lordship. Lordship.
That is true, my lord. I'll ask.
So two things are also being that the recommendation of the committee and the categories who are under exempted category. I shall bring that. I shall bring that, my lord. With
কারা exempted category ভিতরে পড়ছে?
ওই তো land loser, freedom fighter, ex-censors. I shall bring that, my lord. Lordship.
Truly dependent wife. Here the relation of their relation may be considered. Therefore,
Recommendation ought to have been. Lordship. I shall bring that. I shall bring that, my lord.
I'm sorry, my lord.
We have said you file a supplementary affidavit.
Subject to, my lord, yes.
Both these two documents and any other document that you may propose to rely upon after due service
Lordship, I shall.
within 2 weeks.
Lordship.
If he wants, he may file an opposition.
Now, today, my lord, we have filed a reply and opposition today.
Opposition and reply taken on record at the
Lordship,
shop.
Lordship. And Mr. Mukherjee, my AGP, my lord, senior counsel, my lord, he has given me the notification of 2002. I think, my lord, his lordship has seen 2002
Seen it.
notification.
We would like to have a printout when we are hearing the matter.
Lordship.
I shall come.
Then should we not say for filing a supplementary? You can come. But how the committee's recommendation?
Committee recommendation I must
Will
have,
have
my lord. And in that also, my lord, I will, my lord, annex this notification also.
So that we have said.
Lordship,
Yes.
Lordship. Grateful, my lord.
Grateful, my lord.
Item number 15.
Lordship, item 15, Mr. Arjun Rai Mukherjee is appearing for the appellant, Your Lordship. He's not come to court today because his father's been hospitalized, Your Lordship.
Appellant.
Appellant. State is the appellant, Your Lordship.
It's an appeal.
It's an appeal.
Arising out of?
Arising out of the tribunal's order, Your Lordship.
Writ petition, not appeal. Anyway.
Writ petition.
As prayed.
Lordship, 15 to 18 are similar matters, Your Lordship.
No, in all these cases, he is appearing.
In all these cases, Mr. Rai Mukherjee is appearing.
We are informed that Mr. So-and-so
Not this week, Your Lordship. I'm looking for this week, Your Lordship.
now it will come on 27th.
27th. Grateful, Your Lordship.
petitioner কে যদি
So, 6.
Item number 19.
Chief, I appear for the respondent.
Lordship, item 19, I appear for the petitioner. Lordship, in this matter, Mr. Rudraman Bhattacharya, learned senior counsel, has been briefed. He's up for a medical appointment, Lordship. So the matter may be taken anytime next week, Lordship.
As prayed by learned counsel for the petitioner.
Grateful, Lordship.
Item number 20.
My lord, in item number 20, my lord, I am appealing for rest numbers 5 and 7, but I have not served with the copy of the application for substitution, my lord.
Hmm?
5 and 7. Oh,
Not so.
kindly allow us to serve that. Actually, we have served upon the government, upon the state.
State already here.
Yes, yes. So, my lord, to kindly grant us liberty, my lord, to serve. A copy of the substitution application, my lord. This is a substitution application. A different thing. A substitution application. Oh.
He wants pension.
Yes, my minimum pension. Substantive service, but before that, my lord, he served, my lord, for 34 years temporary service. So, my lord, according to my lord, paragraph 18 and 22 of the West Bengal Death Cum Retirement Bill, the temporary service rendered by the, my lord,
18.
20 and 22. 18 already that has been amended, and a notification is issued to the extent that a person who has served 10 years temporary service, then he will be entitled to pension. We are here, my lord, for counting the previous service before being regularized.
Where is that provision?
My lord, page 135. This is the portion of the judgment, my lord, I am reading. Page 135. Paragraph 10. My lord, service of an officer does not qualify for pension unless it conforms to the following condition. To the following conditions, namely, the service must be under government, the employment must be substantive and permanent, or of permanent status or quasi-permanent. The service must be paid by government. Paragraph 11, my lord. Paragraph relevant. The condition of Rule 18B stands relaxed as the memo number 2255F issued by the Finance Department on 22/3/1973, which stipulates that a government servant who has worked continuously as a temporary employee for 10 years or more would be granted pension and gratuity as admissible to permanent government employees under the normal rules.
This is the judgment of Nimai Chand Chatterjee.
Nimachandra Saradi, similar case and identical case is a perimetry adjustment of another department of agricultural department. It's a case of seasonal khalashi, similar to this case. My lord, it requires a exhaustive hearing, my lord.
Give a copy. Serve a copy to the.
My lord.
You are for the accountant general.
Yes, my lord.
The counsel for the accountant general submits that.
I am grateful for that. Much obliged, my lord.
Grateful, your lords.
Go can you-
Item number 21.
I'm for the petitioner, Your Lordship. I am led by Advocate Bikash Chandra Neogi. He could not be here due to some personal reasons. On the last occasion, we were served the affidavit in opposition, Your Lordship. We are praying for 2 weeks' time to file the reply.
This was served on 4th December, 1 month back.
Yes, Lord.
Who is to appear?
Lordship, my senior advocate, Bikash Chandra Neogi.
Item number 22.
My lord, item number 22, I am for the petitioner. I am seeking 2 weeks accommodation in this regard, my lord. Yes, lord.
Item number 23.
Lord, I appear on behalf of the petitioner. May my lord's pleasure be to look into my lord's own order dated 21st of November 2024. A direction was given to pass reasoned order. And to produce it before my lord today.
The revision order has been passed.
Lord, this will not relates to Lord an Amin in the state government service who retired in
So
29.
why did you file the writ when it was still pending?
No, I filed the writ petition because I prayed for 3 reliefs before the learned tribunal. The learned tribunal directed my representation to be considered in respect of 1 prayer. The other 2, with regard to other 2 prayers, Lord, there was no direction. Lord, I came up before this honorable court, apropos, my lord, with only confining my lord, relief to that issue. Insofar as the first issue is concerned, Lord, the other coordinate bench was of the pleasure that since
What are the 3 issues?
Lord, the 3 issues, Lord, kindly comes to Lord, page 119, 119. Lord, page 119, the prayer A, respondent authority, more particularly the respondent number 226, be directed to grant and release all dues by giving increment to the salary of the applicant from 2001 till the date of retirement and the benefit of ROPA 2009 and 2019. This increment and the benefit of ROPA 2009 and 2019, this milord has not been attended to, although have been taken judicial notice of by the learned tribunal. And also a benefit of 25 years service benefit during the service tenure of the applicant, not attended to. Then prayer B, the respondent authority be directed to release the withheld proper salary of the applicant for 11 months in different period of the year 2014 to 2019. Apropos this, my lord, now kindly sees, my lord, the order passed by the learned tribunal. Yes, sir.
Yes, you have given the order.
Yes. I permitted to hand over.
तो আপনার কাছেই সব আছে
The kindly see the last order. Last order dated 9th December 2024. Has been sanctioned 1,200 days leave, extraordinary leave, as per Rule 175.
That means the tribunal has held that because you have been repeatedly taking unauthorized leave, it has only confined the relief to whatever leave was to your credit. Extraordinary leave has been granted, the rest has been rejected.
Lord, in so far as Lord, the order passed by the learned tribunal is concerned, Lord, my prayers, Lord, are twofold. One, that Lord, the benefit of 25 years, Lord, increment. That is, Lord, if I am in service, if I have not been terminated, then my past record, Lord, it does not matter. And so is, Lord, the case in respect of the revision of pay and allowances. Revision of pay and allowances, they inure as a benefit because I am in service. Admittedly, no proceeding has been initiated against me for unauthorized absence.
Can
So-
you earn an increment unless you get pay?
No, the question is, Lord, the pay is only with regard to 11 months. But I have not been granted any increment rights from 2001.
Why do you say 11 months?
11 months.
1,200 days.
1002 days is not 11 months.
No, Lord, they have withheld my salary. My Lord said pay.
The order that has been passed.
Well, because
say 1002 days.
that is for the unauthorized period, my Lord.
So
But-
unless you get the pay, how can you get an increment?
No, the increment, this is not only with regard to the period between 2014 to 2019.
All right.
Increment is since 2001. And the revision of pay and allowances is, Lord, the revision of pay and allowances by the state government came, Lord, in 2009 and 2019. Now, for these two revision of pay and allowances, Lord, I have not been granted, I am entitled to. It is not a fact that I have
What's
not.
your prayer before the tribunal?
Yes.
That
Lord,
is what you are placing right now.
Yes.
That was the prayer before the tribunal.
Yes.
In these very proceedings. In
Yes,
which the
Lord.
final order has been passed.
Yes. And Lord, this order was passed on the basis of a written instruction, Lord, which appears at page 129, which is referred to in the order passed by the learned tribunal. At the time of hearing, this document was shown. Page 129. The tribunal said that since the government wants an opportunity to regularize, so let this be regularized. Apropos my prayer A and prayer B, although the order passed, my lord, it takes notice. Kindly seize, my lord, the order, which my lord would very kindly get, my lord, at page 131. The third paragraph starting with the words.
So this is arising out of a contempt proceedings.
No.
It is
That-
OA number 874 of 20.
OA is not original application.
Then why does it say order stands complied with?
Not because my lord, the direction was not given. Direction was
The
given.
matter has been disposed of.
Yes, my original application has been disposed of by the order which is at page 131. And this is a subject matter of challenge. May I please, my lord, this is 4th April 2024.
No, there is an order of 9/12/24 here. How you are saying 4th April?
9/12.
2024, which has been produced right now.
No, that was not challenged before the tribunal. In terms of the order of the tribunal, this order has been passed by the authority.
No, the matter appears to be pending.
No, my lord.
You are saying 4/4/24.
Yes. But kindly seize page 132. Accordingly, this application is disposed of. The original application was disposed of.
You don't know there is something amiss.
Huh? But my instructions are that it's to dispose of on that day.
Oh, there is a miscellaneous. What is this?
There is this HON'BLE, what do you call it? Number 182.
What are the orders passed which you have handed us? These orders are passed in which proceeding? These orders are much after the 4/4/24 order which they are referring to.
28 November, can you see the order dated 9th December 2024?
Correct.
Now, this order has been passed in terms of the order passed by the tribunal. This order has not been challenged before the tribunal.
Which order? Where is that order?
9th December 2024. Departmental order. That is not the order of the tribunal, that is the order of the department.
I have been invited to participate in a hearing.
No, no, this
hearing
is an order passed by the tribunal. This is not an order passed.
Lord, kindly cease, Lord.
Oh, this is before the additional district magistrate.
ADM. December order, final order.
So he has been appearing there.
Yes. Continuously appeared and submitted documents. Then
In terms of court's order. In terms of courts.
That's all right, but the entire issue has been now considered.
Now kindly, my lord, cease, my lord. In so far as, my lord, the first two prayers, prayer A and B on page 119, they have not.
It is not as if the 1002 days unauthorized absence they have arrived at only with respect to the last of the period. This is for the entire period.
No, the period is specified from 2014 until 2019. That's the period specified. Lord, kindly cease.
Since 2003, since 2003.
Just a second, sir, please.
Please do not misguide the court. Actually absent in office without information. Appears that 1971 unauthorized absence and lives since 2003 had been sanctioned for applicant end of Purva Midnapur dated 11 July 2007 and SGA Tomluk dated 25th April 2013 and 15th October time to time.
May I take my lord to kindly, my lord, page 74 for a moment?
Just a minute.
I'm sorry.
Now this will, it is not that it is only for 2014 to 19. It is from 2001 to 19. The entire period they have said that there are various intermittent periods of unauthorized absence which have to be regularized, and that can be done by the competent authority. Once that is done, the other issues will be considered. So what they have said is 1002 days you don't have any leave to your credit. So they have sanctioned medical leave without pay. Now after this, the consequential action has to be taken. So if they have not taken the consequential action, you will be required to assail these orders. Otherwise, how can we proceed?
No, my lord, the first part, my lord, of the order.
There is no first and second part. You please read the order of the tribunal, which is.
May I, my lord, look, this has been given to me today in course of the proceeding.
Just come to the order impugned.
Yes, my lord.
The third paragraph. Order 4/4/2024.
4/4/24.
Yes, the third paragraph of the impugned order in the writ proceedings.
My lord.
So this is for the entire period. They have come to such conclusion, whether it is correct, incorrect, without considering whatever, it has to be assailed now. You please see the third paragraph. It is not as if it is only for 14 to 19. It is for the entire period from 2001 to 19, including ROPA.
Milord, the unauthorized absence is confined to 2014 to 2009.
That you may say once you have challenged this, they say it is for the entire period 2001 to 2019.
Milord, kindly permit me to read that portion of the tribunal's order.
Yes.
The prayer in this application is for grant of release of all salary dues of the applicant since
2001 to 19.
Yes, because of my prayer A in the OA application.
So from where can you say that they have only considered from 14 to 19? The tribunal has directed that this prayer is for 1 to 19 you consider. This is the consideration.
No, the tribunal did not direct for this.
Oh, yes, it did.
Milord,
From 1 to 19.
Milord,
it does not say that you please consider only for 14 to 19.
Milord, kindly, Milord, permit me, Milord, to read, Milord, in that.
Please read it.
Milord, may I? The third paragraph onward. The prayer in this application is for grant of release of all salary dues of the applicant since 2001 till 2019 with benefits of ROPA 2009 and 2019. Now, by prayer A, Milord, I stand reminded, is for increment from 2001.
It says release of all salary dues to the applicant.
Yes.
It does not say only one particular aspect.
No. I say I stand reminded that my prayer was from 2001.
It also says all salary dues for the period 1 to 19, whether it be a salary with respect to ROPA benefit, it will be a component of the salary with respect to increment basis, whatever.
My prayer.
All salary dues.
That's my prayer.
Is in this context that the tribunal has passed the order.
Milord, may I?
Yes.
Now, Milord, kindly see. From the submissions and records, it appears that the opinion of the Finance Department was sought regarding regularization of 1002 days of unauthorized absence.
Yes.
Memo number 644 dated 1st April 2024 presented by the department suggests that the Finance Department has opined that the Administrative Department is competent to regularize such unauthorized absence as per rules. Accordingly, reference was made to the ADMLR Purbo Midnapur for department to take suitable action. In view of the above reference, respondent number 4 is hereby directed to initiate process of regularization of 1002 days of unauthorized absence of the applicant according to rules and take follow-up action.
Yeah, follow-up action.
Now, 1002 days of leave is, Milord, kindly come to Milord, page 74. That the period, Milord, commences from 2012.
No. This has nothing to do with this order.
Milord, kindly sees the unauthorized absence which, Milord, has been.
This is, if you calculate the total number of days in this, will not come to 1,000.
Milord, I say there was no unauthorized.
Just calculate whether it amounts to
No,
1,000.
Milord, I say, I show it.
You are trying to say this covers the 1,002 days. This does not.
No,
this is part of the 1,000.
Yes.
Yes.
And I say that the commencement of unauthorized absence period, it starts not beyond 2012.
No, it cannot be gathered from this document, sir. It cannot be.
Because, Milord, this is, Milord, a document of 2016.
Maybe.
If there is, Milord, any period and
by inference and by hypothesis, we will not proceed. Will not proceed.
No, Milord, kindly.
This document does not show that it was only a 1,002-day period between 2014 to 2019 because of these dates contained in this.
No,
document.
this is a document of 2016.
Maybe, whatever.
And if, Milord, if there was, Milord, any unauthorized.
If it is our document of 2016, there is no question that it can cover a period up to 2019, like you are saying. You are saying from 14 to 19, how can it cover if it is of document of 2016?
No, Milord, I say
it
this
cannot cover a future unauthorized absence.
I am not saying so, Milord. I show this
document does not.
Milord, I show this document, Milord, for the purpose that prior to 2012, there is no unauthorized absence.
That we cannot say by looking at this document.
Because this is a document of 2016.
Maybe.
And if, my lord, there was any unauthorized absence, this computation would have started not from 14th March 2012, but from that particular date from where.
Now this 1002 days has been sanctioned. Unless it is dealt with, we cannot take up the issue. Impossible. Cannot be done. It cannot be done piecemeal that you two components you do here and the other component will assail that. It cannot be like this. Because the order has been passed in the context of your claim from 1 to 19. This is how they have dealt with it. It may be, it appears to be prima facie. We don't want to say anything, but whatever it is the order. Unless it is assailed by you, how can one go into these issues? One cannot.
But, my lord, also, my lord, kindly, my lord, sees, my lord, this aspect of the matter, that whenever there is a regularization, how this period will be counted is not there at all.
Unless the order is assailed, we will not go into it. We cannot go into it.
My lord, so today, my lord, before my lord, there are.
Today there is nothing.
But today
the tribunal, considering your entire claim, has asked them to consider they have passed an order, whatever it is worth. Unless it is assailed, we cannot proceed. It is a very simple thing you must be understanding. There is no point in
Lord, I do understand, Lord, but insofar as the other two prayers are concerned,
it
that
cannot be.
did
There
not.
is no, it cannot be done in a surgical way, like you are saying.
No, but then this issue, Lord, has to go back to tribunal for consideration.
It has to. What can be done?
So that is, Lord, what I am saying. Lord, kindly remand this back to before the tribunal.
Why remand? You go and you assail this.
No, the two issues will be deemed to have been, my lord, rejected.
It will not. It will not. That is something you are observing against yourself.
I am only apprehending.
You are,
I make three prayers.
You want us to pass an order on apprehension?
No, Lord, kindly.
Should we? That is what we are saying.
No, Lord, I am only, Lord, kindly, Lord, if, Lord, I may be wrong.
Apprehension, we cannot pass.
No, I may be wrong, but the legal consequence of, Lord, an order being passed in respect of one prayer and not in respect
no
of
such order passed in respect of one prayer. This is an order passed in pursuant to the order passed by the tribunal for a period from 2001 to 19.
No, I'm talking about the tribunal's order. The tribunal's order is in respect of only one prayer.
Sir, it cannot be said so.
Regularization of, Lord, regularization of 1002 days.
It cannot be said so.
Lord, kindly see, Lord, page 119 for my satisfaction.
How many times we will see the same?
No, prayer C, I did not press. Lord, kindly see, Lord. That was with regard to 1002 days of regularization. And that is what the tribunal directed.
Prayer C is for retiral dues, sir. It is not. It is not for 1002 days. You did not even know at that point.
Lord, this
1002 days you did not even know at that point of time when you were before the tribunal. There is no prayer regarding 1002 days.
Lord, kindly see.
This has emerged after they have considered that there are 1002 days of leave to your credit. There is no leave, and 1002 day has emerged as per their calculation.
Lord, this is, Lord, emerged, Lord, pursuant to what they have produced before the learned tribunal.
Whatever it is, there is no issue of 1002 days in your prayer. How can it be said?
No. Page 129 was a record before the tribunal. Page 129.
Maybe. There's no way. It cannot be.
Regularizing the leave. Lord, kindly see page 129. This document was, Lord, before the learned tribunal. The order records this document. This 1002 days, this is relatable to my prayer for regularization, the period of absence only. And ROPA 2009, ROPA 2019 has got nothing to do with regularization of this period. My pay scale would be revised. If there is no proceeding against me, they are duty bound to revise my pay scale in terms of the revision of pay and allowances. Also, at page 97, even before I went before the tribunal, page 97, this is a continuous stand that there is this quantified amount of leave. Who is to regularize was an issue. Before the tribunal, they said that yes, the competent authority can issue and approve the order of regularization.
নেক্সট পার্টটা রিটার্নাল বেনিফিট এবং অন্যান্য যা বেনিফিট সেটা আমাকে রিলিজ করতে বলো সিজ দ্য লিভ রিজনস
No, it is, see, this is the issue based on which everything has been held up. They say unless we decide what is the leave to your credit, we cannot do anything further.
No, my lord,
Now they have done
deepest,
it,
my lord,
they
with
will do
deepest,
anything
my lord,
further.
with deepest of respect, my lord, they are trying to, my lord, confuse the
They are
entire.
not confusing, they are very clear. Their stand is very clear. They are not confusing.
Lord, revision of pay, Lord, kindly permit me to say this.
Yes.
Lord, the revision of pay and allowances 2009.
Yes.
Lord, then there was no unauthorized leave. I was not
We don't know whether there was
No,
any
there is no proceeding, admittedly.
For every unauthorized leave, there need not be a proceeding.
No, I say there is no intimation.
1002 days is between 2001 to 19. You're trying to bisect it, will not yield any result in view of the specific order of the tribunal. There is nothing to show that they are excluding any period or including certain period.
Lord, kindly.
The way that you are trying to dissect it cannot be done. The issue is 19 years you have intermittently availed unauthorized leave. They say no leave is standing to your credit, therefore without pay. They have regularized 1002 days in between 2001 to 19.
Very well.
Now, only when they say this issue attains finality that we can work out the other things. Now it is for them to work out the other things. It is not a case of rejection after these 1002 days without salary, whether it will amount to an occasion to a recovery being made or whatever, we don't know. But those things have to be done.
No.
So therefore, as of today, unless the issue is settled and unless this is assailed by you, nothing can be done.
Lord, I say, Lord, this is confined only to regularization. Lord, I put this question to myself.
All right, then we'll consider your submission.
Lord, that the revision of pay and allowances.
All right. So you are saying this is only confined to regularization. Other two issues have not been considered.
Have not been dealt with, and these are uncorrelated.
You don't want to challenge this.
No, how do I have to take instructions?
What do you mean instructions? This is an order.
Lord, I received it in courts of the proceeding today.
Present. Time to you have appeared.
The last, this was
Mr. Mukherjee, do you mean to say if an order is passed in my presence, a copy was given to me?
You please address us, sir.
Lord,
don't address him. He is telling us, you tell us.
Lord, the order may have been, he says the hearing was concluded. That is, Lord, what was apprised to my Lord on the last occasion.
Yes.
Thereafter, we are meeting for the first time today.
Yes.
And my Lord, today in course of the proceeding, this order has been given to me. So I do not have, my Lord, the text of the order available to me.
Correct.
Whether, my Lord, I have to assail this, or, my Lord, I advise my clients, my Lord, to accept this so that he gets the retiral dues early. Lord, is, my Lord, a matter, my Lord, which has to be taken instructions.
That you can say. The order passed by the additional district magistrate
Adjournment. 21st. I'm grateful, man. I'm deeply obliged.
Item number 24.
My lord, item 24 and 25, I am praying for not this week, my lord.
has prayed. List after 1 week. Give your appearance.
January.
Item number 26.
26 I am for the petitioner. In the last occasion, my lords are pleased to direct the state respondent extend the time for filing affidavit in opposition by the state. No opposition has yet been received by me.
By way of last indulgence. 1812. Who is appearing for the state?
Miss Osmita Chakraborty. The last occasion she was there and wait for time for extension of time for filing affidavit in opposition.
Then perhaps they don't want to file, you proceed. We'll take it as if the state does not want to file opposition.
For that matter, Lordship has ordered the prayer for compassionate appointment of the petitioner as sweeper was denied on the ground that the employee have not 2 years of service left when she was declared permanently incapacitated. Well, the mother of the petitioner appointed as a sweeper in Arjikar Medical College and Hospital, my lord, and in the year 1980, and her date of retirement as on superannuation was fixed on 31st of December 2018. But my lord, on 12th of the mother of the petitioner, being the employee, became very ill.
When?
And on 12th of March 2016, she from then she failed to attend his duty and made an application before the authority concerned for
what is the date of application?
Date of application 12th of March 2016. That is
Where is that?
Page 37.
Page 37.
College Director of Health Education. That is at page 37. And when the service was left for 2 years, 9 months, and 19.
What is the date at page 37? What is the date? Where is the date?
Date is written in the below left side. 12th March 2016. Receipt date is there. Received Arjikar Medical College Hospital, 12th March 2016.
You were posted in a hospital.
Hospital, my lord.
And this is addressed to the director.
Yes, my lord. He is the authority. Director of Health Services is the appointing authority.
When you are serving the hospital, it was required to be sent through the superintendent or someone.
Yes, my lord. It was also served on the superintendent. Receipt is there. Received with thanks, Arjikar Medical College and Hospital.
12/3/2016. Yes.
Yes, my lord. And when the service of the mother of the...
Did you give any reminders or any...
Yes, my lord. Reminder is page 3842. That is on 18th of July 2016, 8th of August 2016. Page number 38. Acknowledgement receipt also there. Thereafter, page number 42 and the acknowledgement receipt also there. Thereafter, my lord, after a period of 1 year, 10 months, 12 days, after the date of application, the mother of the petitioner was called for medical examination first time on 24th of January 2018. That is at page 45. And she was advised for further investigation and treatment. Thereafter, further medical examination was held on 11th of July 2018. That is at page 46. Next page. And thereafter, finally, he was examined on 29th of August 2018. That is at page 49.
Month, 2 years, 9 months.
And that is after 2 years, 9 months and 17 days after the application. And she was declared permanently incapacitated for further service of any kind in consequence of so and so. Abul Kais. What we use here.
সস্মিতা চক্রবর্তী
আপনার পাশে।
স্টেট হয়ে আছে
তুমি তো দাঁড়িয়ে চলে গেলাম।
না বাট টাইম নিয়ে ছিল পোস্টাল ইনস্ট্রাকশন পাইনি না আমি জানি আর সিন
Thereafter, kindly see page number 50, my lord. With request to direct her to ask her son Abul Kais to apply for compassionate appointment on the ground in pro forma. Necessary action for appointment on compassionate ground in respect of Abul Kais can only be taken from this end after receiving his prayer. Thereafter, the pro forma application was filed. And thereafter, my lord, the page number 61, first order of rejection is page 61. This is totally non-speaking order without any reason. Observe that ex-employee retired from government service on 31st of December 2018 on the date of normal annuation, hence there is no scope. Thereafter, I filed the original application.
Where is the order passed by them?
Passed by them, the first order is at page 61. Thereafter, I filed an application before the tribunal, and tribunal directed the authority concerned to consider the representation, and thereafter the order was passed on 22nd of March 2023, that is at page 80.
What was her normal date of retirement?
Her normal date of retirement was 31st of December 2018. But she made application on 12th of March 2016.
When she was retired finally, she has retired on the normal date.
He was shown retired as a normal date, though she failed to appear, failed to join his duty, resume his duty on and from.
No, but the fact remains that she has retired. But she has not joined duties from which date?
From 12th of March 2016. From the date of my application.
And where is the order? Page 8.
Page 80 is the order of the authority, and tribunal order is last certified copy.
Page 8. Yes, page 8. Page 8 of?
80. 80 is the
80.
80.
Director of Health
Services.
80.
80.
कम करो सब हो जाएगा। And where is the memo of 312?
Yes, my lord. That is in the file in the last occasion.
31213 memo.
Yes, my lord. That is.
It is there. You have given.
Yes, yes, ma'am. The last occasion. No, no, circular. That is in the third page. Third page B. In case of permanent retirement, the concerned employee had at least 2 years of service left to reach the normal age of superannuation and should fulfill the following conditions. So and so. At least 2 years of service left. আগে যা পেপার ছিল আর কপি নেই
আপনি বলছেন যে আপনি এর মধ্যে কভার
ওইটাই আমাকে রিজেক্ট করেছে
So if in 2016, when you had fallen sick, your mother,
yes ma'am,
you had retired, would you be getting the full pension or not?
no, on after 2016 I have not get any salary.
We are asking you, if you had retired in March 2000,
thereafter pension was.
You would have gotten the full pension or not?
That is I have to instruct.
Huh?
That information is not with me.
But that is, you have to show that. You are relying on B. B1, read B1. What does it say?
in premature retirement.
No, my prayer was rejected on the ground that on the date of declaration of incapacitation, I have not the 2 years of service left.
How many times you will say that?
Yes, ma'am. When
how many times you will say that? You think we have not understood that simple thing? You have already said that.
Yes, ma'am. When
after that, you are relying upon this clause B.
Clause my prayer was rejected by relying upon clause B by the authority.
This is the only provision under which you can claim the benefit.
Yes, ma'am.
So this benefit will have to be subject to the conditions contained in the. What does 2B1 say? Read one.
Yes, ma'am.
See, if for some reason you are prematurely retired and you are not able to get the full pension by virtue of retirement on such date, which must be at least 2 years prior to your retirement, then only you will become eligible. So therefore, the important thing to know is on 16/3/2000, what was the year? 16.
2016.
If you had retired on that date
I was shown retired on the date of my superannuation.
If you don't want to understand, then we can't do anything. Unless he listen to the court, you cannot understand. You are saying the same thing 10 times as if we have not understood. We have understood that. You have applied in March 16, you have not been declared, you are not examined. Finally, they have delayed the issue so that you have retired on your due date of retirement. This you have said 3, 4, 5 times already. We have understood that. But even if they have overlooked this court may, in an appropriate case, subject to what they say, we may say that you will not be held responsible for this delay and you must be offered the premature retirement with effect from 16/3/2016.
Yes, my lord.
Even then, you may not get this. So therefore, you have to read this B1. By avoiding B1, you will not get anything. You please read B1. What does it say?
Then I have to take instruction in that regard.
Because
the
very
proceeding-
simple thing.
Because the proceeding was initiated before before 31st of December 2018. Before the date of superannuation.
That hardly matters.
Yes.
You have to get instruction. So what, did you say this before the tribunal that my mother would not be getting full pension on this date? If this has not been your case anywhere, then can you say it now in these proceedings?
I have to take instruction. I have to take instruction.
You have to. It is the petitioner's entire claim for Item number 27.
And for the petitioner, your lordship.
On the right. Computer on the right. Thank you.
Lordship, I'm for the petitioner. I'm led by Advocate Bikash Ranjan Yogi. He is not present here due to some personal reasons. I'm praying for a week's time, your lordship.
In the morning, which was the matter?
Sir, Ajinur Rahman.
No, in the morning, which was the serial number in which you had made this prayer?
Item number 21.
So same order. 21.
Impugn product
Item number 28.
Well, I'm appearing for the state.
I
Affidavit in opposition and reply is complete, your lordship.
this is
Yes, lordship.
this is the affidavit in reply, my lord.
Yes.
Copy has been served.
Reply taken on record.
Lord, before your lordship takes up the records, Lord, may I just draw your lordship's kind attention? This matter relates to an order passed by the West Bengal Administrative Tribunal, Lord, whereby the earlier order has been modified. Lord, there was a time-bound order to conclude the departmental proceeding against the incumbent. Now, Lord, that time lapsed. They did not conclude. Now, Lord, they prayed for extension. That extension was allowed by the tribunal, keeping the way pending. This is the cause of action which gave rise to the writ petition. Now, kindly see, I am covered by a coordinate bench decision of this honorable court that since there was a time-bound decision by the tribunal to conclude the proceedings, there was no whisper with regard to lapses on my part that I did not cooperate with the inquiry proceeding. This is not their allegation. Therefore, I am entitled to the first order which was passed by the learned tribunal. Now, I am protected by a coordinate bench of this honorable court not to proceed with the departmental proceeding. That interim order is still subsisting, and the exchange of affidavits was directed. That has been done. This is the case, Lord.
My lord, before my learned
Just a minute. Let us go through the order.
Pending it. কিন্তু ওইটা তো
Everything reply there. That order. I am trying to tune our 6 months.
আগের অর্ডারটা বের কর 823
ওই আগেই থাকবে এই যে
চার্জ মেমো লিখতে বল চার্জ মেমো
My lord, 23/9/2022.
20.
2022, 23rd of September 2020.
page 144 বের করে page 144 হয়
And what was the relief in OA of OA 833?
My lord, if I may, my lord. My lord, they in the OA, my lord, they have prayed that they are not praying for the quashing of the entire departmental proceeding. My lord, it was the prayer of the applicant that justice will be served if, my lord, this could be the departmental proceeding, my lord, could be concluded expeditiously.
No, in 833, what was their prayer?
Well, their prayer was to quash the departmental proceeding, my lord.
Entire department.
Entire departmental proceeding.
Selling the charge memo itself.
Yes, your lordship. The entire, well, they have first challenged the
Where
show.
is the order passed on 833 of
Lordship, that is at, my lord, page number. Page number 202, your lordship.
একটা করে রাখতে হবে না অর্ডারটা বের কর অর্ডার আচ্ছা 833 অর্ডার পেজ 202
এই সাথে যেটা চাইছে সিমিলারলি স্যার তাদের ছেড়ে দিন আমাকে বলে
ডিফল্ট ক্লাস ছিল না ডিফল্ট ক্লাস পেয়ারটা বের করবে ওই ওয়ের পেয়ারটা বের কর পেয়ার ইউ উইল পেয়ার ইকুইসিস
And after this, they filed a miscellaneous application.
Yes, your lordship.
Where is the order passed thereupon?
Lordship, the order is at your lordship, page number. My lord, it is at the last, my lord, they have annexed the certified copy.
Certified copy.
Lordship.
order date
The order date is 5th of August 2024.
একে ছেড়ে দিল সিমিলারলি এটাই তো করা নয়
আগে থাকে
আপনি জাজমেন্টে ঢুকিয়ে এই যে আমাদের
বের কর অ্যানেক্স করা আছে নাম টামগুলো দিয়ে দিই
$39 থেকে শুরু হলো সুপ্রিম কোর্ট এটাও ডিসমিসড হচ্ছে
কোনটা
Indian are prosecutor and actor children dismissed. Shivendra Bhattacharjee, police stand and division bench dismissed.
charge memo charge memo page 144
Yes. Now, kindly see I am aggrieved by the order dated 5th August 2024. Your Lordship has seen further extension was allowed.
You don't want them to conclude the proceeding?
Because why should I? Because similarly situated persons on the same charge, they have been exonerated by the order of the tribunal. I also prayed for the same relief. The tribunal.
The order passed in those 4 cases.
Krishna.
আগেরটা বলতে কোনটা
Well, it is there at page number 206.
একটু পিছনে যান স্যার
206 right
শুধু কৃষ্ণা গোরে
this is Krishna Gore was the applicant before the tribunal. Order is dated 4th April 2024.
আমরা সবাই একসঙ্গে একই জায়গায় একইভাবে চার্জ পেয়েছিলাম, যেটা স্যার লাস্টের অর্ডারটাতে নোটিংও নিয়ে আছে, কিন্তু আমাকে রিলিফ দেয়নি, উল্টে সমস্যা নেই।
Same charge memo.
applicant you online I know দাঁড়িয়েছে দাঁড়িয়েছে
অস্মিতা চৌধুরী দাঁড়িয়েছিল।
বোধহয় দেওয়া যাবে না, ও তো দাঁড়িয়েছে ওখানে।
কোঅর্ডিনেট বেঞ্চ হেল্প করেছে স্যার এটা দুটো ডিভিশন আছে
দুটো লাগানো আছে
একটা লাগানো আছে একটা এদিকে আছে, একটা হচ্ছে
This is also arising out of NDPS case number 136 of 70.
Yes, it's same.
The present case also.
Yes.
I have been acquitted.
That judgment of the tribunal you have accepted.
Lordship, we have accepted.
Then
Lordship,
what?
they can take the benefit of the solemn judgment, my lord, before the disciplinary authority. My lord, what has happened when we have prayed extension, we had to, because my lord, their witness did not come up on time. My lord, that has been annexed with the application itself. Your lordship, if may kindly comes, my lord, to page number. Your lordship, page number 203, your lordship will find that 172 days of time, my lord, the witness has taken.
That is their witness, Lord. Prosecution witness, not my witness.
You are asking her something? Yes.
Yes.
Please wait.
My lord, thereafter, what has happened, my lord, there has been several.
That's not the point. The point is totally different. Whether witness has turned up or not is immaterial. If you have accepted,
My lord, in our opposition, my lord, there are
you
several.
have accepted the judgment in case of Krishna Gore, then why should
But the articles of charge, my lord, are different. My lord, they were not the charged officer in that article of charge, my lord. The tribunal has held that, your lordship.
No, they were, he was charged with possessing the seized material.
Lordship, if may kindly comes, my lord, to the order impugned, your lordship.
No.
The
Why,
reason
why are you saying they are not similarly situated?
I bow down before your lordship. They are similarly
Then
situated.
where is the question? Both are facing similar charges. They were members of a raiding team. Some raid has been conducted in respect of an NDPS case, and the allegation is that they have wrongfully possessed some of the seized material. This is the allegation against all of them.
And they are acquitted from there.
They are all acquitted. So there is no basis. Yes, take down. Honorable and counsel for the petition.
for an appeal, just I have checked up, my lord, the appeal is, revision is 13 of 2020.
My lord, order of the ND.
We have asked us.
Just see, my lord, the
Order passed with the APS order.
So we'll not say anything. You prefer appeal against this also.
Yes, appeal.
You may prefer.
Only one appeal.
No.
Appeal against the order, my lord, passed by the NDPS court, your
NDPS
lordship.
court.
Not against the order of the
That
tribunal.
is
What does it?
unconnected.
That doesn't mean.
That is unconnected.
That is unconnected.
Yes. I am extremely grateful to my lord.
Obliged, my lord. Grateful.
Decided by the time we
Item number 29.
be admitted.
This matter I beg to appear on behalf of the respondents.
No, I am for
The
repetition.
petition for filing affidavit, my lord. Due to the difficulties of the department, we could not file an affidavit. You can give me some this time to accommodate us so that we can file an affidavit. As a last one. my lord.
The last chance, as prayed by Mr. Mukherjee, by way of yes, call the next.
Item number 30.
30, my lord, I am for the petitioner.
Sir, just a minute. Lordship, there was a direction of filing the affidavit. I'm filing the affidavit on behalf.
You have served
I've
already.
served also and the reply has also been served.
This is my reply.
Affidavit in opposition and reply are taken on record. Yes, please proceed.
My lord, in affidavit in opposition, there is nothing new. My lord, the learned tribunal after thorough hearing, my lord, passed the order admitting that the petitioner has the master degree prior to the cut-off date of the application for the for appointment to the post in question. That is clear.
So what is the date on which qualification is required is specified in the advertisement.
Lordship.
It has to be prior to submission of application.
Yes.
You have claimed that qualification without this certificate.
No.
That certificate has come to you after the date, last date for filing.
No. Certificate means, Lordship, the provisional certificate that was issued after, but the result was much prior.
That is what we are saying. You say no. When we say that, you say no, and then you say the same thing. That is precisely what we were saying. You have claimed that qualification,
Lordship.
but the certificate was issued after the last date for filing the application.
Lordship.
You said no. That is a fact. So therefore, it is. You will say that it is a technical issue. This is your prayer.
No, that is not technical issue, Lordship.
Then
this is the record that the certificate issued after, but the result
correct
was published much prior.
Even if it was, result was issued prior.
Lordship.
What does the advertisement contemplate? Let us see the advertisement. That will resolve everything. Where is the advertisement?
My lord, if your lordships kindly go through the order passed by the.
Please show the advertisement.
That word is even cool.
It is 20 of or 20 stroke 72 of 2019.
Lordship.
Page 35, your lordship.
P5.
35.
Yes.
That is
That's the
35.
significant-
Is 35 in the writ petition.
ঠিক আছে সাবমিশন করো।
জামা তো ডাকেন কত হয়ে গেছে, টাইম তো হয়ে গেছে যা দেখ।
So where does it specify the date on which certificates have to be acquired?
This is page number 35, your lordship.
Yes.
Only online registration, online applications. Second, only online registration and submission of application shall be allowed on the website www.whrb.in between 14/9/2019 to 21/9/2019 before 8 p.m. This is here, your lordship.
No, no, where does it say the last day for submission of certificates?
Just turn the page on 36, your lordship.
36.
Yes. Candidates must fulfill the essential qualification by the closing date.
Where is that?
That is, application received after the closing date shall be rejected. This will be 1/6. Application received after the closing date shall be rejected.
No, no, that is all right. It's not a question of application being submitted after the closing date. Whether the certificate, there is any closing date for submission of certificate, or does it specify that the certificates have to predate the last date of submission of forms? Is there any such stipulation in this advertisement?
Seems to be a usual practice, your lordship. I can just rely on this one line also, which is there. Candidates must fulfill the essential qualification by the closing date.
Correct.
Yes. And in support of that, your lordship, I just want to rely on a judgment which was passed by our own High Court. It is 2016 SCC online, Cal 12252.
You have it? You have a copy?
Perhaps.
Give us.
I mean,
Please give us 2 copies, don't.
yes. I'm giving 2. 2021 should be the relevant paragraph, your lordship. Relevant paragraphs 20 and 21.
Come to the second paragraph at page 37. Second paragraph at page 37 of the brief.
Yes. Closing date for registration of application.
No, page 37, clause C.
Yes.
Clause C, second
Clause
part,
C.
original certificates relating to.
Require such further proof.
Have you got it?
Yes. Original certificates relating to citizenship by registration, age,
Qualifications, yes, caste.
caste, SC, ST, OBC, physical disability 40% and above shall have to be submitted.
When the WBHRB asks for them. Not at the time of application. Right, we are out of time. We'll due to paucity of time, the matters could not be